I'm going to cover the evidence material, starting with what I might refer to as an issue spotting checklist, and then going through a full outline of the book and filling in from the code definitions and code sections, as well as filling in the issues spotting checklist with anything that appears to be missing based on this first read. So for preliminary considerations, there are 4. 1 is the scope of the rules. Applicants should be prepared to answer that have issues concerning the federal rules of evidence and the California Evidence Code. Applicants should be prepared to compare and contrast the differences between the federal rules and the California Evidence Code, especially where the California Rules of Evidence have no specific counterparts in the federal rules. 2 types of essay formats is narrative and transcript. Third, interrogatory and interrogatories. Example A, narrative format. Assume that in each case, all appropriate objections were made. Did the court err in 1, 2, 3, and 4? And then example B is the transcript format, which would be a question that reads as, assuming all proper objections, claims of privilege, and motions to strike were timely made, did the court properly allow the prosecution to call the witness in item 1 and properly admit the evidence in items 2 through 7? Discuss, answer according to California law. So for the issues checklist, so a lot of that was just answering questions, but for the issue checklist, there's form, purpose, presentation, hearsay, and privileges. Evidence problem-solving approach, I think, is going to read more like an issue spotting checklist. So in the form section, which is the first part of the issues checklist, form not to be written, this step is to gain context. In what form is the essay question? In what form is the forum is the litigation? In what sequence is the evidence produced? And is there a question of counsel quoted on the facts? A, form of the questions, is it narrative or transcript from the earlier examples? B, forum of the litigation, state, California, federal, or civil or criminal. C, sequence of the introduction of evidence, there's plaintiff, prosecution, direct cross, etc. And D, if a question of counsel is quoted, objections to the form of questions. Leading, A. B, calls for a narrative. C, assumes facts not in the evidence. D, compound. E, speculation. 2, objections to answers, non-responsive, move to strike. Purpose, part 2, in the issue checklist. What is the purpose for introducing the evidence? And you've got D, or A through D. A, logical relevance. B, legal relevance. C, character. D, impeachment. So within logical relevance, tendency in reason to prove a disputed fact of consequence more or less probable than it would be without the evidence. Special relevancy problems. Similar happenings, experiments, prior suits, or contracts, negative evidence. Legal relevance. I put a 3 here, which is probative value in excess of prejudicial effect. But that appears to be part of the legal relevance section. So the logical relevance is it going to prove a fact? Make a fact of consequence more or less probable. I don't understand the special relevancy problems. Okay, these are problems with relevancy. And now moving on to legal relevance. You've got extrinsic policy exclusions, including A, liability insurance, B, subsequent remedial conduct, C, settlement offers, D, payment or offer to pay medical expenses, and E, guilty pleas, as well as then your 403 prejudicial to probative and prejudicial balancing test. C, character. Under purpose of introducing evidence, it could, in a substantive manner, it is to prove ultimate issue or circumstantial evidence. In civil cases, it's generally inadmissible. Character in issue by virtue of case, or B, habit. In criminal cases, there's the open door rule and victim character evidence rules. And third, mimic is a mnemonic that stands for the exceptions to the character limitation of motive, identity, modus operandi, intent. I want to say like plan. There's a couple more, which I will add as I get through my own outline. It's not jumping out at me. And lastly, the purpose of entering the evidence could be for impeachment. And it says there's 4 ways. 1 is character. 2 is bias, motive. C is defects in memory, perception, or knowledge. And 4 is inconsistent statements. Within character, A is truth or veracity. B, look to form of character evidence. 1, opinion and reputation. And 2, specific acts. Presentation. How is the evidence being presented? And we have A, B, C, D, E, and F. A is witness, B is document reliability, C is opinion testimony, D is judicial notice, E is burdens of proof, and F is presumptions. So under witness, there's 2 parts: competency, age, and mental, personal knowledge, especially for lay opinions. And for document reliability, there is authentication and best evidence rule. For opinion testimony, there is lay and expert. And then judicial notice, burdens of proof, and presumptions don't have any bullets. And the 4th part of the issue checklist is hearsay. Any out-of-court statement introduced for the purpose of proving the truth of matter asserted. And so that's the definition: out-of-court statement to prove truth of matter asserted. We've got hearsay within hearsay here as part of the definition. Interesting. B, not offered for its truth is not hearsay. Some evidence is not hearsay because it is not being offered for its truth. However, for essay purposes, you should still separately headnote NIRAC the non-hearsay issues. For instance, 1, verbal acts or legally operative acts, words of contract, defamation, for example, and 2, effect of the hearer or reader, for example, to prove notice in negligence case. 3, circumstantial evidence of declarant's state of mind, which we were just talking about, that mnemonic. And 4, non-human declarations, like by an animal or a machine. C, non-hearsay, is prior statements by a witness, prior inconsistent statements, prior consistent statements, and prior identification. 2, under non-hearsay, is admissions, party, vicarious, which is an agent admission, adoptive, which is tacit or silence, and D, co-conspirator statements. So using some of my own words, I would say like 5 is like non-verbal conduct. It kind of as a substitution for non-human declarations in the hearsay that's not offered for its truth, therefore not considered hearsay. And then for non-hearsay as well, adoptive is, another word for that is going to come to me a bit later. Exceptions to hearsay limitations. There are 4 being discussed here, and at least 4 different buckets for 13 different kinds of exceptions, but in total there should be 26. Unavailability exceptions is the first category, and that's when the witness is unavailable. A through C could apply. A, declarations against interest. B, dying declarations. C, former testimony. And then the second classification is reliability exceptions. And I suppose they are viewed as being more reliable than run-of-the-mill hearsay and therefore qualify for an exception. And those include excited utterance, present sense impression, bodily condition, which is really like diagnosis, medical diagnosis and treatment. I don't like the way that they word this. Medical diagnosis and treatment. And present state of mind. So for excited utterance, I have this defined as a statement relating to a startling event or condition made while the declarant was under stress of the excitement it caused. And for present sense impression, I have defined as describe or explain an event or condition while or immediately after the declarant perceived it. The third classification in the exception section is documentary exceptions, including past recollection recorded, business records, and official records, which might be like AKA public records. Others, ancient documents, learned treatises, and the federal catch-all, which is also referred to as another thing. Privileges, any privileged relationship involved. Approach, one privileged relationship, giving you a professional, which I might classify as attorney-client privilege. There's marital, including the spousal testimonial privilege and the confidential marital communications. Within that section, I might say like adverse. I want to say spousal testimony, where we learned that the witness has the right to exercise the privilege, not both spouses. 2, confidential communication. C, holder of privilege, whether or not it was waived, and whether or not there's an exception, which I'm not sure what exceptions they might mean. So that concludes a advanced legal analysis that I wanted to make my issue spotting checklist. And we'll just see about that. Actual outline, I went through the beginning of it, and it really just talks about the background and the development of evidence as it was formed from common law. And constitutional law restrictions, judge-made rules that are both codified and uncodified, federal rules and state rules. Now, there's a Federal Rules of Evidence 601 that kind of talks about the order of the trial. And see how long that section is in the code. It was 601. if we might read that, it gives the judge discretion, a good degree of discretion. But here in the Federal Rule of Evidence, it talks to competency to testify in trial. Every person is competent to be a witness unless these rules provide otherwise. But in a civil case, state law governs the witness's competency regarding a claim or defense for which state law applies the rule of decision. So, okay, I'm sorry, it's 611. That was about the order of the trial. So for competency, that's 601 competency, which is, once again, every person is competent to be a witness unless the rules prove otherwise. But in a civil case, state law governs the witness's competency regarding claim and defense for which state law applies a rule of decision. In other words, what we learned in what is to be seen in my outline is that competency mainly requires personal knowledge and that's considered in Rule 602. A witness may testify to a matter only if the evidence is introduced sufficient to support a finding that the witness has personal knowledge on the matter. Evidence to prove personal knowledge may consist of the witness's own testimony. This rule does not apply to witnesses' expert testimony covered in Rule 703. So, but getting back to the order of the trial and the judicial discretion as it pertains to that order. It's organized unusually. Okay, mode and order of examining witnesses and presenting evidence. Control by the court is Part A. Part B is scope of cross-examination, and C is leading questions. And that's what this section is made up of. So this is the mode order in Rule 611. The court should exercise reasonable control over the mode and order of examining witnesses and presenting evidence so as to make those procedures effective for determining the truth, avoid wasting time, and protect witnesses from harassment or undue embarrassment. The scope of cross-examination should not go beyond the subject matter of the direct examination and matters affecting the witness's credibility. The court may allow inquiry into additional matters as if on direct examination. Leading questions should not be used on direct examination except as necessary to develop the witness's testimony. Ordinarily, the court should allow leading questions on cross-examination and when a party calls a hostile witness an adverse party or a witness identified with an adverse party. I'm not quite sure. Okay, so I didn't really start reading my outline yet. I just kind of am blowing through to the parts that are highlighted because I wanted to look those up in the book. But motions in limine. Okay, I'm sorry. This is actually the order of trial is where I just kind of get 611, starting with motions in limine, and then you have the opening statement, defendant's case, rebuttal case, surrebuttal, and closing arguments, jury instructions, jury deliberation, verdict, and preserving appeals, the right to appeal, the role of the trial judge, extensive authority, extensive discretion, fundamentally operation of entire adversarial system. The trial court judge's authority from 104A, also California Evidence Code 310, 400, and 405. So Let's just go to 104, which I do believe might tell me the definition of like relevance. Preliminary questions. In general, the court must decide any preliminary question about whether a witness is qualified, a privilege exists, or evidence is admissible. And so deciding, the court is not bound by evidence rules except those of unprivileged relevance that depends on a fact. So relevance is here. When the relevance of evidence depends on whether the fact exists, proof must be introduced sufficient to support a finding that the fact does exist. The court may admit the proposed evidence on the condition that the proof be introduced later. And that's all it's said about relevance, actually. So I almost don't even want to mark it. We've got admission of evidence is conditional, i.e. entered on satisfactorily meeting a condition. Admissibility of evidence will turn upon the answer to the question of the existence of the condition. It's kind of conditional evidence. Perhaps what 104 really deals with. I mean, there's more to it. There's conducting a hearing so that the jury cannot hear. The hearing involves the admissibility of a confession. The defendant in a criminal case is a witness and so requests or justice so requires. Here we go. Evidence relevant to weight and credibility. Well, actually, before skipping, cross-examining a defendant in a criminal case by testifying on a preliminary question. A defendant in a criminal case does not become subject to cross-examination on other issues in the case. And the Part E of 104 is evidence relevant to weight and credibility. This rule does not limit a party's right to introduce evidence before the jury, evidence that is relevant to the weight or credibility of other evidence. So let's go to 103 because this goes into trial judges' discretion, and preserving a claim of error is Part A. B, not needing to renew an objection or offer of proof. C, court statement about the ruling directing an offer of proof. D, preventing the jury from hearing inadmissible evidence. And E, taking notice of plain error. Okay, so the definitions, I'm just going backwards and backwards and backwards. There's a scope, and then there's definitions of civil, criminal, public offense record, rule prescribed by the Supreme Court, and then there's purpose in 102, 103 I just read, 104 I just outlined, and test for relevant evidence is actually 401. That's why I got it mixed up. Evidence is relevant if it has any tendency to make a fact more or less probable than it would be without the evidence. So that's not 104, that's 401. And that needs to really be commit to memory, if nothing else. Any tendency to make a fact more or less probable than it would be without the evidence. The fact is of consequence in determining the action. So back to my outline. We set forth the judge's trial discretion of errors and prejudice and what the standard is for, reversible, if plain error, obvious on the record, great discretion, abuse of discretion standard, de novo review of questions of law and questions of fact. And so we'll enter into, we're going to skip all of the cases in this recording, actually, which 1 through 14 came from chapter 1. And we're going to go directly to chapter 2, relevance. Again, evidence is relevant if it is rationally probative in any way, and relevant if it has tendency to prove matter asserted, relationship to situation, and no inherent characteristic. Low probative threshold is the matter more provable with evidence. California Evidence Code material ultimate intermediate evidentiary need not be determinative. Yes, it relates to anything in dispute unless admission would be a waste of judicial time and resources or unduly prejudicial. So take all that with a grain of salt. And then there's a bunch of treatises here. What need be remembered about relevance. Yep, and then there's some cases. But what need be remembered about chapter 2 relevance is simply the definition. Evidence has any tendency to make a fact more or less probable than it would be without the evidence. And we're delving a little bit more into probative force and prejudicial effect. So that would be the 403 analysis, but some of the examples here is illicit emotional result, waste of time, confusion of issue, and misleading jurors. So that is what the content I expect to see in 403. So I'm going to read 403 from the code, which is excluding relevant evidence for prejudice, confusion, waste of time, or other reasons. And the court may exclude relevant evidence if its probative value is substantially outweighed by the danger of one or more of the following: unfair prejudice, confusing the issues, misleading the jury, undue delay, wasting time, or needlessly presenting cumulative evidence. .404 goes into character evidence, which can get into at a later chapter. But its prohibited uses states evidence of a person's character or character trait is not admissible to prove that on a particular occasion the person acted in accordance with the character or trait. I'm going to skip a bunch of chapter 2 cases, except where you see a definition of conditional relevance. Fact is relevant only if another fact is proven. Put another way, the court decides if proofs are sufficient for a jury reasonably to find that condition on the relevancy depends have been fulfilled. And I recall reading that to be by a preponderance of the evidence, which I'm going to write here to be included in jury instructions. After I think the judge makes the first call whether or not that piece of evidence can be seen by the jury for reason of considering conditional relevancy. And so is that definition better than this, which is admission of evidence is conditional, i.e. entered in a satisfactory meeting condition? I like this definition better, and so I'm going to move my sticky into that section. All right, so chapter 3 is about hearsay. There's a preference for via voce proof. And I'm going to find the definition of that before moving forward. Unless it's just not in this section, which I thought it would be. Factual disputes in criminal and civil cases should be decided based on live sworn testimony, not secondhand accounts of what other people said outside of court. So that's actually the definition of via voce. Live sworn testimony, not hearsay, which is secondhand accounts of what other people said outside the court. And this arises from Sir Walter Raleigh's treachery allegation. And there's some value statements given by McCormick, and the order of the witnesses by tradition gives us the first witness and their oath, then the physical evidence, then the cross-examination, and then the second witness, which would be an out-of-court declarant. Declarant's action, utterance. Oh, I'm sorry. This is the triangle, which the declarant's action and utterance goes through ambiguity and insincerity considerations before the jury gets to the part of the triangle of believing the declarant's action or utterance, and then the jury will reach a conclusion after considering erroneousness and faulty perception. Okay, so utterance is documented. Okay, statement, declarant. So there's some terminology given for best interpretation. A declarant is he who makes the statement because the matter asserted used in evidence, both not required. Right? I don't know what that means. Next page. Truth of the matter asserted to prove. Witnesses who see something and speaks about it in court under oath. Okay, so these are just kind of terms that might commonly be used. Truth of the matter asserted to prove truth of claims made by a party offering the evidence, i.e. proposed inferences in the statement offered into evidence. Implied assertions. I like the term proposed inferences, but we're moving to a section titled implied assertions. Hearsay is contextual conduct if offered to prove the truth of what it seems to suggest, i.e. only constitutes a statement of nonverbal conduct intended as a form of communication. So going back to our issues spotting list, what I refer to as nonverbal conduct has a real name called implied assertions. But that definition requires that the non-verbal conduct is intended to communicate. So that's an interesting twist. Let's see if you have a check here. And the case that demonstrates this is Zenny. And for that reason, I'm just going to kind of rewind to where we talked about Zenny. The appeal court overruled objection to entering utterance on the phone as implied assertions of illegal booking and gambling that was not intended to prove a fact. Decision supported in 801 by 801, which makes implied assertions inadmissible. Implied assertions removed from statements of hearsay. So let's call it what it is. This is FRE 801. And I'm just checking to see if this is part of the hearsay section as non-hearsay. It is, yeah. Not offered for its truth, not hearsay. Some evidence is not hearsay because it is not being offered for its truth. However, for essay purposes, you should still separately do an IRAC for non-hearsay issues, and implied assertions fits right in there. And so I'm going to call it FRE 801 instead of hiding the ball. And let's just beat this to death by reading it. Enacted. Okay, whatever. Rules of evidence 901. Authenticating or identifying evidence. Hearsay within hearsay. Which I never really got into that, so I'm going to read that as soon as I'm done reading 801, which 801 is the implied inferences that we've been talking about. On this page. The rule against hearsay is 802. 801, definitions that apply to this article, exclusions from hearsay. Statement means a person's oral assertion, written assertion, or nonverbal conduct if the person intended it as an assertion. So to be hearsay, okay. So in what I just wrote down, within the non-hearsay section is non-verbal conduct, unless intended to communicate a statement. So there you go. Declarant, we said the person who made the statement, hearsay, means a statement that a declarant does not make while testifying at the current trial or hearing, and a party offers an evidence to prove the truth of the matter asserted in the statement. Statements that are not hearsay are a declarant witness's prior statement. I might keep this page open because I think that's going to be the next thing that we get to. Oh, look, not hearsay. Okay, I have some note cards on this stuff too. that we'll want to make sure get placed in the right spot. All right, so within my outline, we stopped at implied assertion. Talking about Zenny's approach, advisory on 801, the triangulating hearsay that I discussed, non-assertive conduct and assertive conduct. So that's kind of interesting, is that nonverbal conduct that's assertive is not going to be thought of as insincere, whereas if it's not non-assertive, it could have been meant to deceive. So there's a couple other points, right? Assertive is more reliable than non-assertive, which could have been meant to deceive. I'm beating this to death. I hope this is in the essay. All right, right to confront. Hearsay and confrontation, which is a Sixth Amendment constitutional right, the right to be confronted with the witnesses against him. Now, we're not really going to find that in this book. I don't believe, but just kind of checking the first section. Really, no, and it's as basic as that. So I'm just going to mark this as the confrontation clause as not very long when you reduce it to this basically right to be confronted with the witnesses against him. The right to confront applies to criminal proceedings, belongs to the accused, satisfied when the accused is confronted in court, and should be subject to examination. Got a couple cases on the topic. We'll move on through the cases, except to stop at the harmless error standard. Which I believe comes from Chapman versus California. And the problem is that, okay, yeah, that is here. Prosecution to show error to be harmless beyond a reasonable doubt is the standard. But there's a lot of different ways to say that. And I think I blew past them in chapter 1, and it might be better to... Oh, here's the plain error doctrine from 701. It's sort of part of it. Kind of, sort of part of it. And what's this? Okay, so the cases contain some rules. And so I'm going to go back to them. SCOTUS held there to be no emergency when wife gave statements she was implicated, adverse interest, out of court statement. This is about the confrontation clause, just applying it in this case. It shouldn't have been highlighted. All right, so this is where we were going. We've arrived. at what's a plain error? Reversible if plain error, obvious on the record, facts of the case, gravity of the offense, substantial rights violated. Right. So this is how each of the circuits view this differently. God, I just love the fact that did I skip all this? I guess I did. So via voce is the preferred proof, which is live testimony, sworn testimony, subject to cross-examination. And leading questions are questions that suggest a desired answer. Laying the foundation is a process of satisfying whatever requirements the rules set for introduction of evidence necessary to predicate and to admit marked exhibit into evidence and show jury. So that's going to be your best definition of foundation. And it's going to just have to be here with via voce, leading question, and foundation. Now, which is part 2 or page 2 of my outline. Okay, so when it comes to prejudice, first you have to find an error which substantially affects the rights of the parties. This is error, prejudice, and then like standards. Trial judge's discretion, again 103, takes these into account. In the Ninth Circuit, there's a test of more probably harmless than not. In the Third Circuit, there's more onerous. Reversal if not highly probable that verdict would be the same without the error that we found. And then in the Fifth Court, it goes to judge discretion. For example, reversible of plain error, obvious on the record, facts by looking at either the facts of the case, the gravity of the offense, or the substantial rights being violated. And there's, in the treaties, we talk about how there's great discretion to the judge. There's abuse of discretion standard in the de novo review of questions of law and questions of fact. So these are manners of reversing decisions. And I'm just going to leave it at that. Standards of review of errors. We didn't really miss anything else except for 701. Yeah, which is the plain error doctrine. Somewhere between 701 and 103, we find the plain error doctrine, but I actually do recall it being in 701. So I'm going to go navigate to 701, which says, and this has to do with opinion testimony by a lay witness. So I'm actually going to not go back to that. I'm going to retract. And then 702 has to do with the opinion of an expert witness. So it has nothing to do with plain error. 103 has to do with plain error. try to get back to page 12 where we were. Nine, 10, 11, 12. Confrontation clause, right to be confronted with witnesses against them, nothing special. Declarant is who made this statement. Don't need all this confusing stuff. Okay, we're talking about Chapman versus California. But that case came to us in criminal procedure, and I don't have anything about it in this book, besides naming it as the Ninth Circuit's standard for reversible errors, which beyond reasonable doubt. Which is actually not actually stupid. That's not what it is. Right, I was on page 14. Exceptions to the hearsay rule. Just some background on it, according to McCormick, and according to the advisory committee. Evidence rule is better than no rules or no evidence, and that's a joke. They think that the 403 analysis is probably better than this rule-based format, but some would say that gives too much discretion, unpredictable results, difficulty for practitioners, and difficulty distinguishing or adding on to, anyhow, there's a wild card exception, which is held out according to the advisory committee note, provision for hearsay statements not within one of the specified exceptions. I still don't have the actual name of it. So sometimes it's called wild card. In our issues spotting checklist, it was referred to as federal catch-all. Wild card is another one. Its actual name starts with an R. I don't remember what it is, but it'll come to me. All right, so type prior statements by witness, and I held this page in the code. I want to say it's 801, but type 1 is when the declarant's available, and therefore it's not the one that I'm looking at in the code. So let's read 803. 803, exceptions to the rule against hearsay regardless whether the declarant is available as a witness. So this is the type. Prior statements by witness is the type where the witness is available. It doesn't matter if they're available or not available. But a section I was looking at, 801, I think requires that they're not available. All right. Prior inconsistent statement. Prior statements by witness. Okay, yeah. Prior statements by witness when they're not available is what my outline is talking about, type 2. And it says that that comes from 804. So my outline is directing me to 803 and 804. 803 consists of literally 24 exceptions. The closest one to prior statement looks to be it doesn't really look to be here. So I'm not going to jump to any conclusions here, but I'm very much willing to just read this from 801, which says, a declarant witnesses prior statement. The declarant testifies and is subject to cross-examination about a prior statement, and the statement is consistent with the declarant's testimony and was given, so this is the inconsistent, I just said inconsistent with the declarant's testimony, and was given under penalty of perjury at a trial hearing or other proceeding or a deposition. When it's consistent with the declarant's testimony and is offered to rebut a express or implied charge that the declarant recently fabricated it or acted from a recent improper influence or motive in so testifying, or to rehabilitate the declarant's credibility as a witness when attacked on another ground. I'm going to say non-hearsay is covered in like 801, definitions and non-hearsay, but also within D1, 801 D1 speaks to prior statements. And it doesn't say anything about whether the party is available or not. I think they're available and they're making the statement, and it's either consistent or inconsistent. An opposing party statement. A statement is offered against an opposing party and was made by a party in an individual or representative capacity, is one the party manifested that it adopted and or believed to be true, was made by a person whom the party authorized to make a statement on subject, was made by the party's agent or employee on a matter within the scope of the relationship and while it existed, or was made by the party's conspirator during the furtherance of the conspiracy. So this one's co-conspirator. A lot of this is vicarious and agent. But before, I'm going to read all of the exceptions, and then I'm going to go to 804, which also talks about prior statements. So in Rule 803, exceptions to the rule against hearsay, regardless whether the declarant is available as a witness. The following are not excluded by the rule against hearsay, regardless of whether the declarant is available as a witness. Not excluded by the rule against hearsay, which means these are exclusions to hearsay. Present sense impression. A statement describing or explaining an event or condition made while or immediately after the declarant perceived it, excited utterance, a statement relating to a startling event or condition made while the declarant was under the stress of excitement that it caused, then existing mental, emotional, or physical condition, a statement that and this is going to be the last thing I say before I take a break. What is then existing mental, emotional, or physical condition? A statement of the declarant's then existing state of mind, such as motive, intent, or plan by emotional, sensory, or physical conditions such as mental, feeling, pain, or bodily health, but not including a statement of memory or belief to prove the fact remembered or believed unless it relates to the validity or term of the declarant's will. For statements made for medical diagnosis or treatment, a statement that is made for and is reasonably pertinent to medical diagnosis or treatment and describes medical history, past or present symptoms or sensations, their inception or their general cause, recorded recollection, a record that is on a matter the witness once knew about, but now cannot recall well enough to testify fully and accurately. And accurately reflects the witness's knowledge. If admitted, the record may be read into evidence, but may be received as an exhibit only if offered by an adverse party. So there's recorded recollection and there's recollection refreshed. And we're going to talk about the difference from my essay. One of the two may be read into evidence, but may be received as exhibit only if offered by an adverse party. So we'll see. Records of a regularly conducted activity. A record of an act, event, condition, opinion, or diagnosis if the record was made at or near the time by or from information transmitted by someone with knowledge. The record was kept in the course of regularly conducted activity by a business, organization, occupation, or calling, whether or not for profit. Making the record was a regular practice of the activity. All these conditions are shown by the testimony of the custodian or another qualified witness, or by certification that complies with Rule 902, which has to do with authentication, 11 or 12, or with a statute permitting certification. And E, the opponent does not show that the source of information or the method or circumstances of preparation indicate a lack of trustworthiness, which I'm going to put like dash testimonial. Absence of a record of a regularly conducted activity, evidence that a matter is not included in a record described in paragraph 6 if the evidence is admitted to prove that the matter did not occur or exist. B, a record was regularly kept for a matter of that kind. And C, the opponent does not show that the possible source of the information or other circumstances indicate a lack of trustworthiness. Public records, a record or statement of a public office if it sets out the office's activities. Romanet 2, a matter observed while under a legal duty to report, but not including in a criminal case a matter observed by law enforcement personnel. Or Romanet 3, in a civil case or against the government. In a criminal case, factual findings from a legally authorized investigation. And in public records from public office if the opponent does not show that the source of the information or other circumstances indicate a lack of trustworthiness. Public records of vital statistics, a record of birth, death, or marriage if reported to a public office in accordance with legal duty. Absence of a public record. I'm going to skip that one. Records of religious organizations concerning personal or family history. Certificates of marriage, baptism, and similar ceremonies. And family records. Records of documents that affect an interest in property, the record of a document that purports to establish an affected interest in property if A, B, or C. The record is admitted to prove the contents of the original recorded document along with its signing and its delivery by each person who purports to have signed it, but the record is kept in public office and the statute is recording documents of that kind in that office. Statements and documents that affect an interest in property. Again, statements in ancient documents. A statement in a document that was prepared before 1998 and whose authenticity is established. 17, marker reports and similar commercial publications. 18, statements in learned treatises, periodicals, or pamphlets. A statement contained in one of those if the statement is called to the attention of an expert witness on cross-examination or relied upon by the expert on direct examination, and the publication is established as a reliable source by the expert's admission or testimony, by another expert's testimony, or by judicial notice. If admitted, the statement may be read into evidence but not received as an exhibit. Reputation concerning personal or family history. Reputation concerning boundaries or general history. Reputation concerning character. Judgment of a previous conviction. So this I'll read. Actually, I'll read the beginning of reputation concerning personal or family history. A reputation among a person's family by blood, adoption, or marriage, among a person's associates, or in the community concerning that person's birth, adoption, legitimacy, ancestry, marriage, divorce, death, relationship by blood, adoption, or marriage, or similar facts of personal or family history. For reputation concerning boundaries or general history, a reputation in the community arising for the controversy concerning boundaries of land in the community or customs that affect the land, or concerning general historical events important to that community, state, or nation. Reputation concerning character, a reputation among a person's associates or in the community concerning a person's character. And judgment of a previous conviction, evidence of a final judgment of conviction if the judgment was entered after a trial or guilty plea, but not a nolo contendere plea. The conviction was for a crime punishable by death or by imprisonment for more than a year. The evidence was admitted to prove any fact essential to the judgment, and when offered by the prosecutor in a criminal case for a purpose other than impeachment, the judgment was against the defendant. The pendency of an appeal may be shown, but does not affect admissibility. A judgment involving personal, family, or general history or boundary, a judgment that is admitted to prove a matter of personal, family, or general history or boundaries if the matter was essential to the judgment and could be proved by evidence of reputation and other exceptions, which was transferred to Rule 807, is basically all of those that we consider exceptions to hearsay. But really, they're exceptions to the rule against hearsay. Hearsay is what's not permitted, and these are exceptions that allow it to be admitted. So 804, exceptions to the rule against hearsay when the declarant is unavailable as a witness. The criteria for being unavailable. And then there's what looks like more exceptions. Former testimony, statement under the belief of imminent death, statement of personal or family history, other statement offered against a party that wrongfully caused the declarant's unavailability. And what else? That kind of concludes that section. So there's a couple more exceptions. (804) exceptions when witness is unavailable. And I'm going to read those just because it wouldn't make sense to read them in another recording. So here's the criteria for being unavailable. A declarant is considered to be unavailable as a witness if the declarant is exempted from testifying about the matter of the declarant statement because the court rules that a privilege applies, refuses to testify about the subject matter despite a court order to do so, testifies to not remembering the subject matter, or cannot be present or testify at the trial or hearing because of death or then existing infirmity, physical illness, or mental illness, or is absent from the trial or hearing, and the statement's proponent has not been able by process or other reasonable means to procure A, the declarant's attendance in the case of a hearsay exception under Rule 804B1 or 6, or B, the declarant's attendance or testimony in the case of a hearsay exception under Rule 804B2, 3, or 4, which I'm about to read. 804B is the exceptions. The following are not excluded by the rule against hearsay if the defendant is unavailable as a witness. So this is more or less provided these people are unavailable, these exceptions to hearsay exist, I think. Testimony that was given as a witness and this is former testimony, was given as a witness at a trial hearing or lawful deposition, whether given during the current proceeding or a different one, and is now offered against a party who had, or in a civil case whose predecessor in interest had an opportunity and similar motive to develop it by direct, cross, or redirect examination. Statement under the belief of imminent death in a prosecution for homicide or in a civil case, a statement that the declarant, while believing the declarant's death to be imminent, made about its case or circumstances. And third, statement against interest, a statement that, it's funny how short this dying declaration thing is. It's really just saying, I mean, it has to be related to a homicide in a criminal, in prosecution for homicide or in a civil case. A statement that the declarant, while believing the declarant's death to be imminent, so it requires the belief made about its cause or circumstances. So it has to be related. To the reason for the belief of the imminent death. So statement against interest, a statement that a reasonable person in the declarant's position would have made only if the person believed it to be true, because when made, it was so contrary to the declarant's proprietary pecuniary interest or had so great a tendency to invalidate the declarant's claim against someone else or to expose the declarant to civil or criminal liability, and is supported by corroborating circumstances that clearly indicate its trustworthiness if it is offered in a criminal case as one that tends to expose the declarant to criminal liability. So it should be supported by corroborating circumstances. And statement of personal or family history, the declarant's own birth, adoption, and legitimacy, ancestry, marriage, divorce, relationship by blood, adoption, or marriage, or similar facts of personal or family history, even though the declarant had no way of acquiring personal knowledge about the fact or another person concerning any of these facts, as well as death, if the declarant was related to a person by blood, adoption, or marriage, or was so intimately associated with the person's family that the declarant's information is likely to be accurate. Other exceptions transferred to Rule 807. So 807 is other, and I am going to read that other hearsay exceptions in a moment. Now, you've got like one added, which is a statement offered against a party that wrongfully caused the declarant's unavailability. A statement offered against a party that wrongfully caused or acquiesced in wrongfully causing the declarant's unavailability as a witness and did so intending that result. So acquiesce is the word I was looking for in the issue spotting checklist for adoptive omissions. So tacit or silent or acquiesce. Okay. So moving to 807, which I think will conclude our exceptions to the rule against hearsay. Sounds like so confusing. Attacking and supporting a declarant's credibility. Oh, hearsay within hearsay. Hearsay within hearsay is not excluded by the rule against hearsay if each part of the combined statement conforms with an exception to the rule. So let's not forget that exception. I didn't really think of it as an exception, but it is. Hearsay within hearsay. 805. Here's one, attacking and supporting a declarant's credibility. And residual exception. This is the one, the word is residual. 807. Residual exception. So in the issue spotting checklist, when we refer to the thing as, how do we refer to it as? What even is it? Oh, the catch-all, the federal catch-all. Okay, that really is referred to as residual. Thank you, 807. Okay, in general, under the following circumstances, a hearsay statement is not excluded by the rule against hearsay, even if the statement is not admissible under the hearsay exception in Rule 803 or 804. The statement is supported by sufficient guarantees of trustworthiness after considering the totality of the circumstances under which it was made and evidence, if any, corroborating the statement. It is more probative on the point for which it is offered than any other evidence that the proponent can obtain through reasonable efforts. Notice the statement is admissible only if the proponent gives the adverse party reasonable notice of the intent to offer the statement, including its substantive and declarant's name, so that the party has a fair opportunity to meet it. The notice must be provided in writing before the hearing or trial, or in any form during the hearing or trial if the court, for good cause, excuses a lack of earlier notice. And that's just the judicial notice that we read in the issue spotting checklist. But we read that judicial notice from, it's its own section in presentation. I'm going to give that the reference of 807 question mark. And I'm going to end this recording and begin again with my outline on page 15.